Welcome to 2025, which is probably going to be one of the most litigious periods in our lifetime. For many newbies, litigious means when people sue each other. The country is completely divided, and so there are going to be disputes between family members and business partners and employers versus employees, to mention very few. Also, with our new media, hardly a day goes by without somebody claiming defamation. However, if you're like most Americans, you pretty much had your bank account cleaned out over the past couple of years, and therefore you can't afford a lawyer to help you resolve your disputes. That's where you come in. You have to take matters into your own hands using the tools provided to you in our legal system. People give up very easily because they think big corporations and government have more power than they. But the opposite is true. It's really a 50-50 proposition. But if you don't at least try, it's a 100% proposition that they win. Also, there are many ways to resolve a dispute without going to court. Oftentimes, you can resolve a dispute by avoiding the dispute altogether. If you see a red flag, believe it. Once that ship sails and you get into a situation where you are in a dispute, try and reason with the other side to get out of that dispute. Oftentimes, this starts with a demand letter or a cease and desist, or possibly even an offer in compromise. This involves monetary compensation. These tools often work at avoiding the expense of a court case. But let's say you do have to file a lawsuit. If you're savvy, you can write your own. There are plenty of exemplars on the internet to assist you. If you're not, you can hire somebody like me to assist you in the writing and even guiding you through the legal process. Generally speaking, when a paralegal works for an attorney, they're allowed a great deal of latitude because they are the supervising attorney. But ultimately, it is the attorney who is accountable for anything that paralegal does. This holds true for you as well. Even if you have the best paralegal as a self-represented litigant, you are the supervising attorney and ultimately have to stay involved in your case. While this may seem difficult, even when you have an attorney, you should be staying on top of your case as much as you can. More often than not, your attorney is not as passionate about your case as you are. Oftentimes, they don't even read it until the day of the first court action, where they have to appear before the judge. The other thing that you have over a corporation that you have a dispute with is that they tend to have to spend a lot more money than you. Now, corporations cannot self-represent. They must hire attorneys or use in-house counsel. You, as an individual, may also be eligible for fee waivers because of your low income. Also, an incompetent attorney can lose your case and have left no appealable causes. Now that's because they failed to use the magical word, objection. If you represent yourself, that's a very important word to learn. The other sad fact is that judges have very little respect for self-represented litigants. The judges are generally arrogant and like to be part of the club, which means our elite legal system. Every once in a while, you'll get a judge that is extremely fair, and as long as you follow court procedure, he or she will treat you with the respect that our Constitution affords you. Judges are responsible for ensuring that self-represented litigants are fairly heard. They can do this by providing information about the proceedings, asking neutral questions, modifying the order of taking evidence, avoiding legal jargon, explaining the basis for their rulings, and referring litigants to resources for assistance. I'll be honest with you, though, what I just told you happens very rarely. The judges seem to enjoy punishing you for representing yourself. So many of these things that they're supposed to do and that they should do, they do not do. Since our system is as imperfect as most others, there is nobody that will hold them accountable ethically. The Constitution mainly speaks to criminal law, which we won't deal with at all. This is not because we do not recommend it. However, when freedom is on the line, we tend to recommend you find an attorney if possible. But again, nobody knows your case as well as you do. So if you're willing to do the work, which is comprised mostly of knowing how to navigate the system and do the legal research, I say go ahead. Civil actions, which are basically our disputes against others for material reasons, are also covered by various other laws. For example, with regard to federal courts in the United States, the right to represent yourself in civil litigation is codified in 28 U.S.C. 1654. This means you can file a civil action in federal court without an attorney, and you will be called a pro se litigant. All state courts have rules that allow people to represent themselves in civil matters, also known as pro se representation. The legal term pro se comes from Latin and means for oneself. As you can see, my email is also Latin, and it says in pro per. It means basically the same thing. In future videos, I will be discussing various cases that I've worked on and how they played out, as well as various obstacles you are likely to encounter and how to overcome them. We'll see you next time.